lights out for the sheriff. You can't leave off Bill Walsh. You can't leave off Bill Walsh. Even though I know it's written, still with the four guys.
Good morning.
Good morning, Judge. My name is Matt Batters. I'm here for the plaintiff.
Okay, Mr. Batters, how are you this morning?
Very well, sir. This is my first opportunity to appear before you, and so pleasure to make your acquaintance and have you make mine.
Well, thank you. Good to meet you as well. And Ms. Escobar, are you going to take the record here today?
Good morning, Judge. Yes, I am.
Okay. Mr.
Nice to
Batters,
meet you.
are we going to have any witnesses, or just going to be your argument this morning? Or?
It's just going to be my argument, and I'll be the witness on attorney's fees.
Okay, that's very good. Okay, we can go on the record now. You got any questions of me, Ms. Escobar, before we start?
No, just if you want to call the case.
I will, okay. We're here on cause number DC 22-17354. It's a case to style King Operations versus Eastman et al. And can I get your announcement for the record, Mr. Batters?
Yes, my name is Matt Batters with the law firm Drought, and Bobbitt for the plaintiff.
Thank you very much. We're here on a motion for default, and Mr. Batters, you may proceed.
Good morning. May it please the court. That's correct. We're here on our motion for final default judgment. Our petition was originally filed in December. As set forth in our motion, the defendants were served with process. There are two defendants in this case. The first one is a limited partnership. The second one is the general partner of the limited partnership. Both defendants' registered agents were served with process, and exhibits 1 and 2 to our motion are the proof of service from the process server. Those are also tendered with our motion for default judgment. Those are tendered with our exhibit list for today at this hearing. Secondly, we exercised reasonable diligence to ascertain the address and identity based on the Texas Secretary of State records. Exhibits 6, 7 for our hearing today are the screenshots of the Texas Secretary of State records on the date that we filed our petition, and I will represent to the court that none of the material has been updated since December 16th. Okay, Exhibit 4 to our motion is our attorney's fees affidavit. This is a suit on a sworn account as well as a suit on a written contract. Our law firm incurred $8,405 in attorney fees and expenses in the amount of $755.50 in bringing this case to the point that it's at today. Our prospective fees in the event of a motion to set aside a default judgment would be $5,000 for a new trial. In the event it was appealed to a court of appeals, $12,500. And if it was appealed further to the Texas Supreme Court, another $12,500. Your Honor, the nature of this case is a complex oil and gas arrangement, and it's perhaps one of the most unusual suits on a sworn account I've ever had, because the evidence of how much the defendants owe us is actually provided to my client by mail each month in the form of a statement that says, here's how much you owe, except at some point they stopped including checks with those statements. So those are attached to our petition as exhibits, and that forms the basis of our calculation of damages. So the total amount of damages we're seeking today in the order is $107,854.07. Again, that's coupled with the attorney's fees of $8,405, cost of suit of $755.50. We are also asking for pre-judgment interest on all of the above amounts at 5% and post-judgment interest at 18% per year.
Okay, Mr. Batters, can you break out the actual damages from, I know you have, I'm looking at your proposed order, and you have your economic damages. Is that a total of 107? That includes the attorney's fees, et cetera?
No, sir, that does not. Economic damages are solely 107.
I got you. Okay, anything further?
Nothing further, Your Honor. I think I would wish to reiterate and reincorporate and reaffirm all the facts pled in my affidavit about my attorney's fees, which were reasonable and necessary based on the criteria that the Supreme Court has outlined for reasonable and necessary attorney fees.
All right, thank you very much, Mr. Batters. The court, having heard argument of counsel and having reviewed all pleadings on file, the court finds that both defendants have been duly served and have failed to appear. The court finds in the plaintiff's favor and renders a default against those defendants as a result of their lack of appearance and their lack to file an answer. The court will award damages, economic damages in the amount of $107,854.07. In addition, the court will award attorney's fees in the amount of $8,405 and also court costs in the amount of $755.50. The court will not award any future attorney's fees. Mr. Batters, I do not award speculative attorney's fees. If that does arise and you have to incur costs to pursue that matter, you can seek your attorney's fees at that time. And at that point, this will be a final judgment and it will be appealable as of this date. Anything further, Mr. Batters?
Nothing further. Thank you, Your Honor.
All right, thank you very much. You two have a nice day.